Breaking: Esther Lungu wins round in court. Court says only banks can produce bank Recordsa.
Good day, and welcome back to InspirAfrica Official.
Tonight, a major twist in the long-running legal saga surrounding former First Lady Esther Lungu. In a decision that's already shaking Zambia's legal and political circles, the court has ruled that only banks, not the state, can produce her financial records. This ruling could change everything, not just for the Lungu family, but for how financial investigations are handled in Zambia. So, what does this mean for the ongoing corruption cases? Is this a victory for privacy, or a loophole in the fight against financial crimes? Stay with us, because what unfolded in court today reveals much more than meets the eye. 4 months, former First Lady Esther Lungu has been fighting to clear her name amid investigations into alleged proceeds of crime. Authorities have claimed her assets, from homes to accounts, were linked to suspicious transactions. But her lawyers have repeatedly pushed back, saying due process was ignored. And now, a judge appears to agree, ruling that only banks have the legal authority to produce client records. This ruling isn't just about paperwork, it's about the limits of state power, privacy rights, and how justice is served in politically sensitive cases. Let's break down exactly what happened, and what it could mean for Zambia's broader fight against corruption. This decision could reshape how financial investigations are conducted in Zambia and raises key questions about privacy, legal process, and political influence. Join us as we unpack the implications of this ruling, the arguments made by Esther Lungu's legal team, and what this means for the ongoing legal battles involving the former First family. Don't forget to like, comment, and subscribe for more updates on Zambia's biggest political and legal stories. Only on InspirAfrica Official. The revelation came to light last week on October 23, 2025, when the Court of Appeal delivered its judgment in Esther Nyawa-Tembo Lungu v. Director of Public Prosecutions, Appeal number 59/2024. Let me take you back to where this all began. Esther Nyawa-Tembo Lungu is the former First Lady of the Republic of Zambia, wife to the 6th President, Edgar Chagwa Lungu, who served from 2015 to 2021. Following the change in administration, the Drug Enforcement Commission, the DEC, began investigating properties linked to Mrs. Lungu. They suspected these assets were proceeds of crime, tainted by corruption during her husband's tenure in office. The DEC seized multiple properties in which Mrs. Lungu held an interest. Through the Director of Public Prosecutions, they filed an application in the High Court, specifically the Economic and Financial Crimes Court Division, seeking what's called a non-conviction forfeiture. In simple terms, they wanted to confiscate the properties and hand them over to the state without necessarily securing a criminal conviction against Mrs. Lungu herself. The properties in question? 15 double-story flats valued at 66 million kwacha. Luxury real estate that raised eyebrows across the nation. Mrs. Lungu didn't take this lying down. She filed an application as an interested party, claiming legitimate ownership over these properties. And that's when the legal battle truly began. During the proceedings at the High Court level, the DEC produced bank statements as evidence. These weren't just any statements, they belonged to the Esther Lungu Foundation, a charitable organization bearing the former First Lady's name. The statements showed financial transactions, account balances, money transfers, the kind of forensic paper trail prosecutors dream about. But here's the critical detail. These bank statements were not produced in court by officials from Zanaco Bank or FNB Bank, where the accounts were held. Instead, they were presented by a DEC officer, an investigator who had interviewed the bankers during the investigation and collected the documents. In 2024, the Economic and Financial Crimes Court ruled against Mrs. Lungu. The High Court ordered the forfeiture of the 15 flats to the state. Mrs. Lungu immediately filed an appeal, raising 5 grounds of challenge. Among them was a seemingly technical objection. The bank statements had been improperly admitted into evidence. Most legal observers dismissed this argument as a desperate attempt to find technicalities. After all, the documents were authentic, weren't they? They came from the banks during a legitimate investigation. Surely that was enough. But Mrs. Lungu's legal team knew something the prosecutors had overlooked. And they pressed forward. The Court of Appeal judgment, delivered by a 3-judge panel, Justices Chalwim Chenga, Petronella Ngulyub, and Yvonne Chemb, was unequivocal in its findings. The court stated in its written judgment, This case underscores the need to follow the provisions of the Evidence, Banker's Book, Act, Chapter 44 of the Laws of Zambia when adducing evidence in court relating to bank records such as statements, accounts, transfers, etc. The judges continued. Even when the police or any law enforcement agencies have accessed these bank documents, they ought to be submitted to court by the bank who are the custodians of the records. Let that sink in for a moment. Even when law enforcement legally obtains bank records during an investigation, those records cannot be presented in court by the investigators themselves. They must be produced by the bank. The judgment went further, addressing the specific violation in this case. The court noted that the state had presented bank documents, including Lungu's Zanako account number and Esther Lungu Foundation trust accounts at FNB, without testimony from a bank official, violating Section 5 of the Evidence, Banker's Book, Act. And here was the devastating conclusion. No bank official gave evidence to prove these documents as original and correct. Think about what this means. The state's lawyers walked into court with authentic bank statements. They had obtained them through proper investigative channels. The documents were real. The transactions they documented were real. But none of that mattered, because they forgot one crucial step: bringing a bank official to testify. Legal commentator Dixon Jerry, writing for the Zambian Observer, expressed astonishment at the state's error. "I cannot understand why the state got it wrong on bank statements. Those documents were in the custody of Zanako, and the state would not have got hold of them if the bank had not cooperated. Why didn't the state summon as a witness an officer from Zanako?" Jerry continued, his frustration evident. This mistake was too basic, and only a trainee lawyer at Ziale would be excused for getting it wrong. Ziale, the Zambia Institute of Advanced Legal Education, is where Zambian lawyers receive their final professional training. Jerry was essentially saying this was a mistake a law student might make, not a team of experienced prosecutors handling a high-profile forfeiture case. The Court of Appeal's ruling was surgical in its precision. Of Mrs. Lungu's 5 grounds of appeal, 4 were dismissed. But that one ground, the third ground, challenging the admissibility of the bank statements, succeeded completely. The court ordered. Only the third ground had merit, ordering the expungement of the specified exhibits. Expungement. The bank statements were struck from the record. Legally, it was as if they had never existed. All those damning transactions, all those detailed financial trails, gone. Now, it's crucial to understand what this ruling does not mean. The Court of Appeal explicitly stated. The ruling was delivered by a panel of judges, Chalwim Chenga, Petronella Ngulyub, and Yvonne Chemb, who concluded that only the third ground had merit. All other grounds, including claims of being denied the right to be heard and constitutional references, were dismissed. And perhaps most significantly, the Court of Appeal has ruled that forfeiture proceedings against former First Lady Esther Lungu relating to the K's 66 million worth luxurious flats were properly commenced before the Economic and Financial Crimes Division, EFCC, of the High Court. So Mrs. Lungu's other arguments failed. The forfeiture proceedings were valid. The court had jurisdiction. The process was constitutional. But those bank statements, inadmissible. So what does this victory actually mean for Esther Lungu? Let's be clear. The 15 flats have not been returned to her. The forfeiture order still stands. The Court of Appeal ruled that the proceedings were properly commenced and that most of her legal objections were without merit. But the expungement of the bank statements is a significant setback for the prosecution. Bank statements are the backbone of financial crime investigations. They show money trails, they demonstrate patterns of transactions, they connect people to accounts and accounts to assets. Without those statements in evidence, the state's case becomes considerably weaker. They'll need to rebuild their evidence using other means, and they'll have to do it properly this time. The procedural requirements under the Evidence, Banker's Book, Act exist for good reasons. They ensure authenticity. They allow for cross-examination of bank officials about record-keeping practices. They protect against forgery and manipulation. They maintain the integrity of financial evidence. As Dixon Jerry noted in his analysis, I, however, welcome the Court of Appeal's judgment. I strongly encourage Esther Lungu to appeal to the Supreme Court so that the apex court can pronounce itself on this landmark case. This is indeed likely headed to Zambia's Supreme Court, the final court of appeal. The legal questions raised are significant enough to warrant the highest judicial scrutiny. But there's a darker undercurrent to this story that we cannot ignore. How did experienced prosecutors make such a fundamental error? Was it simple incompetence? Were they understaffed and overworked, rushing through a complex case? Or was there such confidence in the outcome, such certainty that the courts would side with the state against a politically unpopular defendant, that they grew careless? These questions matter because Esther Lungu is not the only person facing the Zambian justice system. Every day, ordinary citizens are investigated, prosecuted, and convicted based on evidence presented in court. If the prosecutors handling the most high-profile case in the country can't follow basic evidentiary rules, what's happening in the cases no one is watching? There's also a political dimension we must consider. The current government, led by President Hakainde Hichilema, has made anti-corruption a centerpiece of its agenda. The prosecution of former First family members sends a powerful message. No one is above the law. But that message becomes muddied when the prosecutions themselves violate legal procedure. When the state cuts corners, even against genuinely corrupt defendants, it undermines public confidence in the entire system. And let's address the elephant in the room. The public reaction has been deeply divided. Some Zambians see this ruling as proof that the justice system works, that even the powerful must follow the rules, and that Mrs. Lungu's rights were properly protected by the Court of Appeal. Others are furious, viewing this as a technicality that allows a corrupt individual to escape justice. As one commenter wrote in response to the news, "Once a thief, always a thief. How did criminal Esther get K66 meter?" Another asked, "Why is Esther doing Mingalado when knows very well that those flats are stolen property? Why did she not buy them before his main became president?" These are legitimate questions. The properties in question are indeed luxury flats worth millions. They were acquired during her husband's presidency. The optics are terrible, but the law is not about optics. It's about process, about procedure, about ensuring that even unpopular defendants receive fair treatment under established legal rules. As one legal observer put it, that's a serious matter that should concern all of us. Stealing in public life has been sanitized by some corrupt clergymen in various Christian denominations. In fact, the Zambian state is being charitable with Esther Lungu. As investigatory agencies, both the ACC and DEC are not yet up to scratch. The reference to the Anti-Corruption Commission and Drug Enforcement Commission not being up to scratch speaks volumes. These agencies have enormous power, the power to investigate, to seize assets, to destroy reputations. But power without competence is dangerous. And competence means following the law. All of it, even the boring procedural bits. So where does this leave us? Esther Lungu has won this round, but the fight is far from over. The case remains active. The state can, and likely will, seek to introduce the bank statements properly, this time bringing bank officials to testify. Or they can build their case using other evidence. But this ruling will echo far beyond one former First Lady's legal troubles. It sets a precedent. It reminds prosecutors that procedural rules exist for everyone, that even the most politically motivated case must follow legal requirements, and that Zambian courts are willing to enforce those requirements even when it's unpopular. That's encouraging. That speaks to judicial independence, to the rule of law, to the notion that justice is blind. But it also exposes serious weaknesses in Zambia's prosecutorial capacity. And those weaknesses should concern every Zambian, regardless of political affiliation. Because the next person facing prosecution might be you, or your brother, or your mother. And when that day comes, you'll want to know that the state is following its own rules. Thank you for watching this edition of InspirAfrica Official. I want to hear from you. Do you think the Court of Appeal made the right decision? Should procedural rules be strictly enforced even when they benefit unpopular defendants? Or should courts find ways to admit evidence when the underlying facts seem clear? Leave your thoughts in the comments below. Let's have a real conversation about justice, procedure, and the rule of law in Zambia. We'll be back tomorrow with more news, more analysis, and more stories that matter to our continent. Until then, this is Nakash signing off. Stay informed, stay engaged, stay inspired.